Good morning, everybody. Well, yesterday we dwell on mainly, maybe exclusively, on law, climate change, biodiversity, and law, with reference to international law and domestic legislations on this matter. And we heard many interesting reports on the role played by judges, international and domestic, to fight against the climate change and biodiversity loss. Today we will split about different approaches, not solely juridical, but also in other fields. It is of common knowledge that climate change has an overall impact on daily life of people, on economy, on politics, on culture, on traditions of different populations around the world. And this session, entitled Evolving Approaches to Cope with Climate Change and Biodiversity Loss, aims at giving us an idea of various impacts in various sectors of climate change. And in particular, while yesterday we were more de jure condito, dealing with existing applicable law and laws and rules and practices, nowadays we will more focus on what's going on in order to face this big problem, which is climate change. And we will start with the activities of the UN International Law Commission with Professor Nesi, which will entertain us on climate change and sea level rise, progress and challenges at the International Law Commission. Giuseppe Nesi is a full professor of international law and the law of international institutions at the Faculty of Law of the University of Trento, where he was also Dean for 6 years, but he's most importantly a member of the International Law Commission of the United Nations nowadays, having served in the past as legal advisor of the President of the UN General Assembly and legal advisor at the Italian permanent mission to the UN. And therefore, Professor Nesi will tell us what the International Law Commission is thinking about this big issue, which is sea level rise because of climate change. Please, the floor is yours.
Thank you, Ida. Thank you very much. I'm very pleased to be here, and I will start by thanking Centro Nazionale delle Ricerche, and in particular Gemma Andreone, who has been brave enough to organize this very important international colloquium. So thank you very much, Gemma, and I will say also this very timely international meeting. So I, as my colleague and friend Ida Caracciolo, is also the chair of this panel, as anticipated, I will speak about climate change and sea level rise, progress and challenges at the ILC, at the International Law Commission. I started by saying that sea levels have risen more in the last century than in the past 3,000 years. The Intergovernmental Panel on Climate Change has demonstrated that at the current rate of temperature increase caused by anthropogenic climate change, sea levels could rise by more than 1 meter in the next 75 years. This phenomenon is of particular concern to coastal states, especially small island states, for whom rising sea levels pose an existential threat. But make no mistake, sea level rise will literally change the face of our planet. Infrastructure in ports and straits that underpins the global economy will have to be updated, and 2.4 billion people currently living in coastal areas may see their livelihoods redefined to their core. Everyone will be affected by it. This is not an issue to be taken lightly. Given the global scale and severity of this threat, 10 years ago, the international community of states, I would say, although there were important studies that started even before, began to recognize the need to address it from an international legal perspective. In 2015, the General Assembly identified sea level rise as a risk to island and coastal countries in the 2030 agenda. The risk for their survival and the need to protect fundamental rights has prompted the Pacific Island Forums and the Alliance of Small Island States to publish declarations and address the issue before international bodies. Since then, the ICJ, as we have heard yesterday, and ITLOS have both been asked to deliver advisory opinions that touch on the subject. Also, the Security Council devoted in 2023 a meeting to sea level rise and its consequences on the maintenance of international peace and security. More than 80 states participated in this debate. My intervention will focus on the work of the ILC on the issue, which began in 2018 following a request from the state of Micronesia, among others. The way in which the ILC's work on sea level rise began marks a first in the work of the Commission. This is an important point to note. New topics are usually considered following a proposal by ILC members, but this was the first time that a topic was included in the program of work following a request by a state. This significant development demonstrates that states are beginning to view the Commission as a body that can help them address emerging issues through a legal lens. The ILC's ability to address this topic in such a short time has bolstered its credibility and centrality in international lawmaking. From 2019 onwards, the ILC had to understand how to approach the topic in accordance with its methods of work. This resulted in an adaptation of the ILC's usual methodology through the creation of a study group of 5 members. While study groups have been created in the past on other topics, these past study groups benefited from the participation of the ILC member who had proposed the topic. This absence prompted the study group to divide its work into several subtopics of sea level rise and to deliver its outcomes as soon as possible. In doing so, the Commission demonstrated its commitments to dealing with the topic expediently, owing to the urgent need to find legal solutions following states' requests. To this end, the study group presented 4 reports to the Commission. The first report of 2021 attempted to narrow down the relevant issues a process that a member of the Commission described as a vacuuming activity. Following this, in 2023, the study group decided to focus on three interrelated clusters: the law of the sea, statehood, and the protection of persons affected by sea level rise. Each cluster, therefore, addresses a different legal challenge posed by sea level rise, reflecting a holistic attempt to clarify international law while inevitably engaging in progressive development due to the nature of the topic. This led to the adoption of a final report by the study group in just 2 years, which is an achievement for the times of the LC, an impressive result, also in light of the UN liquidity crisis. You know that in this year, the session of the Commission was shortened from 12 weeks to 5 because of the so-called liquidity crisis, which in my opinion is something else, but we can leave this aside. This is a sort of manifestation of the boycott attitude of some states towards the UN system as such. I never wear in my life a pin, but I feel that I have to wear here the pin of the United Nations. I will briefly present the content of each cluster to provide an overview of the results. The first cluster, which concerns the law of the sea, primarily deals with the stability of maritime entitlements in the phase of shifting baselines. The most obvious consequence of rising sea levels is the shifting of coastlines, which could lead to changes in maritime entitlements. Under a conservative reading of ITLOS, the breadth of maritime zones is measured from coastal baselines, and if coastlines recede, these zones also recede, resulting in significant losses of sovereign rights for coastal and island states. Building upon state practice and the regional declarations, including the 2021 Pacific Island Forum Leaders Declaration on preserving maritime zones in the phase of climate change-related sea level rise, the IC study group noted an emerging trend towards the stability or fixity of baselines once lawfully established. Notably, UNCLOS does not obligate states to update baselines, geographical coordinates, the outer limits of maritime zones, and the charts reflecting them once duly submitted to the Secretary General. This approach reflects how the principles of stability, predictability, and equity have underpinned the IC's work on sea level rise. Although this position is not yet enshrined in customary international law, the IC has emphasized that such a rule is emerging and will protect the rights and security of vulnerable states, particularly small island developing states. This position has been welcomed by a majority of states, as evidenced by their comments to the Sixth Committee 2 weeks ago. Only a small number of states voiced concerns, primarily invoking historical rights or the need to fix baselines based on the low water line. But these were really exceptions. And I must say that I was touched by the idea that even at the UN today, the most vulnerable, the weakest states find protection. You know, we live in a world in which it seems that things are upside down, no? And the power as such should prevail always and forever. And this is not what the UN says, the UN Charter says. This is not what the UN has been created for. So the fact that at the General Assembly of the UN there is this strong feeling towards the protection of the most vulnerable is something that must be taken into account. The second cluster addresses another concerning consequence of rising sea levels: the impact of submergence on statehood. The traditional criteria of statehood, namely defined, as you know, territory, permanent population, government, and capacity to enter into relation with other states, seem to take physical permanence for granted. Tragically, this is no longer guaranteed for some island nations. Acknowledging the existential nature of this issue, the ILC has drawn upon emerging practice to suggest that statehood should not automatically be extinguished merely because a territory becomes uninhabitable or submerged. This conclusion is based on the right of states to preserve their territorial integrity, the right of peoples to self-determination, another principle we are very akin to, and the need to ensure stability, certainty, and predictability in international relations. To achieve this, affected states can adopt measures to preserve their statehood under international law. Examples include digitizing archives, mapping maritime boundaries, and considering government-in-exile arrangements. Therefore, the Commission's work signals a gradual shift towards recognizing the continuity of statehood in the context of climate-induced territorial loss, a conclusion supported by the majority of states within the Sixth Committee. Some concerns have been voiced regarding the absence of sufficient practice to sustain the presumption of continuity in international law. Nevertheless, a trend is emerging in favor of continuity of statehood, which the ILC has reinforced through its work. The third and final cluster focuses on the human dimension, addressing the rights and protection of individuals displaced or otherwise affected by rising sea levels. This area of law intersects with international human rights law, refugee law, environmental law, and disaster law, as none of these legal frameworks clearly address the impact of sea level rise of individuals. The 1951 Refugee Convention, someone would like to abolish, does not recognize environmental degradation as grounds for refugee status. And only a few cases in human rights law have considered sea level rise to be a threat to the right to life, as in the Teitiota versus New Zealand case. The ILC's work has emphasized the need to integrate existing legal regime to protect affected persons, particularly through the principles of human dignity and solidarity, and the duty to cooperate. The study group has attempted to identify practical solutions, such as humanitarian visas and climate mobility agreements, demonstrating once again the practical nature of both the approach and the outcome of its work. Yet the study group stopped short of proposing a new legal regime, opting instead to lay the foundations on which such an edifice may be built in years to come. The ILC's work has achieved several notable advances. Firstly, it has contributed to the elevation of sea level rise to a matter of international legal concern, while previously it had been examined primarily from an environmental point of view. In doing so, it has consolidated emerging state practice, particularly with regard to the fixity of baselines and the continuity of statehood. This is already evident in states' declaration within the Sixth Committee, as well as in the work of the ICJ, and also the huge participation of states in the procedure in its recent advisory opinion on climate change. We discussed at length yesterday, where the ILC's work has been cited to support the view that there is no obligation to update baselines. Most importantly, The ILC has established a shared vocabulary that enables states, scholars, and institutions to engage in debate on these issues from a common legal standpoint. Some remaining challenges can be identified. Firstly, many of the ILC's progressive conclusions are based on limited regional practice. Without broader, consistent state practice, their customary nature remains uncertain. Secondly, while the ILC operates within its legal mandate, actualization of its conclusions requires cooperation with other institutions, such as the International Maritime Organization, the UN Division for Ocean Institutions, such affairs and the law of the sea, the UN Framework Convention on Climate Change, and the UN High Commissioner for Refugees, to state just a few, adding institutional complexities to the matter. Lastly, the ILC's work cannot fully address climate justice by establishing common but differentiated responsibilities for states that contribute most to sea level rise at the expense of affected states. But this is simply because it does not have the competence to do so. The hope is that the work of the ILC will spark further developments, initiating a process that is currently left to states. In particular, existing instruments should be interpreted in a way that addresses sea level rise and contributes to its development through subsequent agreements and practices. Also in this regard, of course, the work of the International Law Commission could be extremely helpful, the work that has already been done. The next step could be the adoption of new instruments, whether binding or non-binding, that reflect and advance the work of the ILC. This depends on the political will of states, but the general consensus on the final report may already demonstrate a certain predisposition in this regard. In conclusion, the ILC's work demonstrates the capacity of international law to adapt to unprecedented global transformations. Working on this topic has enabled the ILC to showcase its ability to address current legal challenges, including by adapting its working methods to emerging priorities. This flexibility has empowered the Commission to have an immediate impact on the development of international law with respect to urgent issues. As the ILC's former chair, Patricia Galvao-Teles, another good friend of mine, said, sea level rise is a test of international law's resilience. I would add that it has also provided a testament to the ILC's own resilience in these concerning times, when the importance of its mission must be reaffirmed with force. The threat of sea level rise continues to loom on the horizon, and law alone cannot solve it. But within its mandate, the ILC has been able to single out reasonable responses and place discussions on this cataclysmic topic on solid and informed legal grounds. And I thank you very much.
Thank you very much, Pepe. Let me share with you a couple of considerations. First consideration, which is a very light one. First time I heard about sea level rise many years ago from a scholar who is deeply involved in studying this issue. He told me, he asked me, but Ida, do you know the gin tonic effect? I don't drink gin, I hate tonic water, so I have never seen anything than the melting of ice cube in a glass, a tumbler of gin tonic, And he told me this is the sea level rise effect. So from gin tonic at 11:30 in the morning to most serious issues. Well, Professor Nesi showed us the complexity of the topic. Any topic dealt with by the ILC is a complex topic, of course, but this is a topic which is complex since it is cross-cutting. It includes all international law, and I think that the words of Patricia are clear in that sense, and therefore it requires a huge amount of work, scientific work, but also mediation work, because you know, if you move something on one side, another side will be starting crackling, so it is necessary to taking everything together. And this task is afforded by the Commission in a period of time when multilateralism and the belief, confiance in the United Nations and all its bodies is not so strong as it was in the past. I know that multilateralism is still strong in the field of the law of the sea, because small island states are numerous, not so important in terms of territorial mass, but important in terms of maritime spaces, and therefore they are able to contrast certain more conservative positions from big states, powers, we all know. But anyway, there are also topics such as stateless, effect of sea level rise on statehood, and refugees, and so on, which are outside, let's say, the scope of the law of the sea, and which must be dealt with by the Commission. So good luck, and I hope that the Commission will produce, as usual, a good work, and states will accept in a certain way it. And then we will still remain in the legal field with Professor Lorenzo Schiano di Pepe, which will touch upon a topic, global shipping and climate change, the IMO strategy to cut GHG's emissions, which is extremely important, because I must say that shipping has been very committed in trying to reduce GHG emissions, even if there are sectors which are much more polluting and emitting a major quantity of greenhouse gases. But shipping has been very clever so far, at least on the paper, and therefore it is an example we should know. Professor Schiano di Pepe is a full professor of law at the University of Genova, where he teaches European Union law and law of the sea. He is active in the field of law of the sea, since he's a member of the advisory board on the law of the sea. He is a co-editor in chief of the Rivista Giuridica dell'Ambiente and coordinator of an interest group, the interest group on the law of the sea of the Italian Society of International Law, and he's also a member of the governing board of the Italian Maritime Law Association. So therefore he will be very, will give you a very overall idea of the topic. Please, the floor is yours.
Thank you very much, Ida. Thank you very much, Judge Caracciolo. and it is a great pleasure to be here today. And congratulations to Gemandreone for putting together such an interesting event, and to the National Research Council for hosting us in this beautiful room. It is always a pleasure for me to go back to what has been the topic or the focus of the first stage of my academic career, IMO and vessel source pollution. It is the first time that I speak about a regulation of shipping under the watchful eye of Christopher Columbus, and this puts me in a difficult somehow position, but it shows how rules have evolved. They need to evolve, and well, the important role played by international fora such as the International Maritime Organization. I would like to, in the time that has been allocated to me, I would like to discuss three aspects of the topic that has been assigned to me. First, to give an overall idea for those who may not be aware of the mechanisms according to which shipping-related rules are elaborated within the International Maritime Organization. Secondly, I would like to illustrate the variety of tools that have been developed and adopted at IMO or within the IMO for the purpose of fighting against atmospheric pollution caused by shipping. And thirdly, well, try to answer the question, where are we now and where do we go or could we go from here in the future? The future is perhaps not as bright as the optimistic words of Professor Caracciolo would indicate. I have a visual support, mainly because a lot of acronyms come into play in this field, and so I thought it was a good idea to fix them in writing for those who may want to study in more depth any of these issues. We are still in the, of course, United Nations framework. The International Maritime Organization is a specialized agency of the United Nations, quite successful in terms of membership, and its focus is the promotion of maritime safety, efficiency of navigation, and the prevention of marine pollution from ships. It is a focus which is interpreted rather strictly, meaning that the IMO, in its recent practice, is in principle opposing or objecting or refusing project works which do not fit strictly within one of these topic areas. It is important to note that since we are celebrating the Maritime Safety and Security Journal, that efficiency of navigation also includes security issues, because navigation can be safe, can be efficient only insofar as it is conducted in a secure manner. Can we say that IMO, well, the IMO works similarly to other international organizations within the UN family, but it does have its own peculiarities. can we say that it has a lawmaking role? Yes, with some, of course, specifications and precisions. It is a forum for discussing the possible adoption of new treaty instruments. So it is not a legislature itself, but rather a place which facilitates the carrying out of intergovernmental conferences. And this is true as far as both the adoption of new instruments as well as the amendment of existing instruments are concerned. However, when it comes to the amendment of technical aspects of existing treaties, and technical aspects may be in the form of technical annexes or figures that define a particular threshold, or limits when it comes to caps to liability and compensation. When we are talking about these aspects which do not go to the heart of the legal concepts or the legal principles of an international law instruments, we can say with a grain of salt that IMO has a quasi-legislative role. Why? Because a system is in place by which one of the committees within the IMO may come up with the proposed amendment, and if the amendment is circulated among the states parties to that particular agreement, if the amendment does not receive the opposition of a certain significant number of states parties, generally this is 1/3, the amendment will enter automatically into force after a period of 10 or 12 months for those states which have not objected to its content. So we are in a situation where international law instruments can be amended without going through the usual conventional processes. One of the areas in which we can, the use of this tacit amendment procedure has been experienced, is in the context of the MARPOL 1973-78 Convention. This is the main instrument covering marine pollution from ships, where, with particular regard to the prevention of pollution of the marine environment, both from operational and accidental causes. This convention has several annexes. The first two annexes are compulsory, meaning that you cannot be a state party to MARPOL without accepting the content of Annex 1 and 2. The other annexes are optional, but the number of ratifications they have attracted is quite high and significant. This is also true of Annex 6, which is the annex which is of interest for us, because it deals with atmospheric pollution caused by vessels. Originally, when it was adopted in 1997, it aimed at limiting the emissions of sulfur oxides and nitrogen oxides from ships' exhaust. It intended to prohibit the deliberate emission of ozone-depleting substances, and it was also aimed at the possibility of designating emission control areas. But this regime has, and this is the, let's say, second part so to speak, of the presentation today, has evolved and included a number of additional features. There are basically 3 steps if you want to think about this issue in terms of advancements. One in 2011, one in 2018, and one in 2023. At these different stages, different types of technical measures or operational measures were introduced. One example is the EEDI, Energy Efficiency Design Index. Basically, this is a technical measure. It applies to a new, to the so-called new builds, so the ships that are newly built after a certain year, and it requires that a certain standard is reached, a standard which is calculated taking into account some features of the ship, including its design and the way in which it has been built. There is no prescription as to how a ship should be built, but the effects of the physical feature of the ship on atmospheric pollution is taken into account. I'm moving forward, and I will then move back again. A similar standard has been adopted in 2018 in relation to existing ships. So basically the EEDI, previous slide, and the EEXI, present slide, work according to the same in the same way, but they apply to different categories, new and existing. Of course, the standard for existing is a one-time check, whilst the standard for new builds changes and becomes higher and higher in terms of coefficient or environmentally friendly coefficient as the years pass. So there is a baseline coefficient to be attained initially at the entry into force of this technical standard, and this gets reduced and reduced and reduced as the phases passes. There is also another type of measure, that is the Ship Energy Efficiently Management Plan. This does not relate to how a ship look like, but rather how it is operated, because of course the environmental impact of a ship also depends on the itinerary that a ship follows, the speed at which she travels, and so on. And initially this measure was a way to somehow monitor and record the performance of ships in that respect. The situation changed in 2018, when these 2 additional measures or tools were introduced, CII and the CS, because these were, with the introduction of these 2 instruments, the energy efficiency plan was given additional teeth. The bottom line in this respect is a standard measure for collection of data was introduced, the CS, and failure to attain a certain level of performance would trigger additional procedural obligations for the ship and her owner in terms of ship efficiencies management plan. Most recent development, and I'm entering the third and last phase of my presentation. In 2023, IMO tries to make the big step by introducing a net zero target to be achieved indicatively by 2015. Here there is a link with the previous presentation, because part of the package was the assistance to least developed countries and small island developing states, and, as I will say in a moment, also the creation of a fund whose proceeds would be intended for use for technical assistance for states in a situation of disadvantage, such as small island states. Technically, it was expected that these new amendments would be adopted a few weeks ago at the meeting of the MEPC, the Marine Environmental Protection Committee of the International Maritime Organization, but MEPC failed to find a consensus around this topic, and quite something which is not so frequent. The meeting went to a vote, and the majority of the votes were expressed in favor of an adjournment and of delaying the discussion and decision of 1 year. So the meeting will take place again in 1 year's time, and we will see what happens in the meantime. The idea was to create a complex system by which target zero would be achieved around 2050, but what was more reason of controversy, a system of emission trading was also proposed as part of the deal, part of the package, by which ships could be able to sell and purchase emission units depending on their performance against the assigned target. Much criticism around this proposal by the industry, especially European industry, not happy about this, a replica of what is in place in Europe and an additional burden for us, they said. First is a quote from one of the outlets which represents the industry's views. President Trump took the time to express his views on this topic, and you can read his statement on Truth, his social network, a few hours before the meeting at IMO would take place. I don't think it is quite frequent that the President of the United States say something about the IMO, and I'm not sure whether they were flattered or worried about that. And the rest I've just said, impossibility to reach a consensus and so on. What can we, well, of course, no conclusion is possible because this is an ongoing matter, but IMO has been successful because of its technical nature. It's a technical body where politics remains out of the meeting room, out of the door. So insofar as the measures which are proposed and discussed are of a technical nature, everything goes well. And IMO has been successful for many years, of course with problems, but problems which have been solved in due time and due course. The problem here is that the regulation of marine pollution from ships, environmental law in general, environmental policy in general, is becoming more and more politicized, and which makes it possible for politicians to intervene and somehow to disrupt what would be otherwise a normal discussion about technical people. So we don't know how this will end, but we have something today which we did not have a few months ago. We have ITLOS advisory opinion on climate change. So we have a way in which UNCLOS has been interpreted, which somehow support the work of IMO, and that was not there a few months ago. And I think this should be used, although maybe this is not a convincing argument for the United States, but it may be a convincing argument for other states, as a overall chapeau for the discussion going forward. Thank you very much.
Thank you, Lorenzo. The advisory opinion mentioned many times IMO strategy, net zero, as a good practice in the field of limiting, reducing the carbon dioxide, mainly emissions. But unfortunately, the panorama changed rather soon. Within 1 year, everything is upside down in a certain way. I think that, let's say, the problem with IMO is that the long way of criticisms against the UN is reaching the shores of IMO, notwithstanding being a technical agency within the UN family, and the vote is based on fleets. So, you know, we are dealing with maritime law, but in a logic that economically more important, because having a big fleets have more votes and the force are powerful within IMO. I met a couple of weeks ago some members of the legal office of the IMO, and they were rather, yes, sad and tired, let's say, because of these stressful negotiations, and replying some questions by the audience. At a certain point they said, but we have to mediate. This is a continuous mediation within IMO. Is not, we are not in the position to decide about anything. We are in the position of mediate, but this, the result depends on states, which are the subject, primary subjects of international law. And well, now we will leave the field, maybe the safe field for us, being jurists of international law, and we will see the climate change and biodiversity issues under the perspective of sociology, and in particular, Professor Jing Luo will speak about climate change, biodiversity, and social justice in China, policy, innovation, and global role. We need not to forget that human beings and the way they cooperate, interact, are the first targets in a certain way of climate change. Professor Jing Luo is a researcher at the Institute of Chinese Borderland Studies, Chinese Academy of Social Sciences. She is a member of the Chinese Sociological Association, chairman of the Professional Committee on Social Survey and Research Methods under the Chinese Sociological Association. And she is also Deputy Secretary General of the 4th Decision-Making Advisory Committee of the State Ethnic Affairs Commission, and it is her research fields encompass contemporary Chinese borderlands governance and social transformations in these borderlands. Please, the floor is yours.
Thank you, Ida, and thank Jim to invite me here. To be honored to be here. And I come from the Institute of Chinese Borderland Studies of CAS. So my institute research on Chinese borderland, and we are a very young institute of CAS, only 42 years. We are founded at 1983. So as the issue of the borderland study is young, and same with the climate change issue, because it is also a government priorities, just like the climate change. This issue in China is very totally unlike in Europe. The climate change topic is driven by multiple actors in Europe, and confined and interacting efforts of various social forces. For example, at the grassroots level, Europe has a long-standing and vibrant tradition of environmental movements. And the academic community, the business sector, also play an important role in the climate change issue. But it's totally different in China. In contrast to Europe's complex and diversity of multiple actors, China has demonstrated that a powerful top-down driving force in addressing the climate change discourse. So it's totally different context. This driving model stems from Chinese unique political system and social development needs. So the Chinese government attached great importance to the climate change issue and has put this issue to our national strategy level. So my research are on the Chinese social issue context. And additionally, my major is not law, my major is sociology. And same with Max Weber, Giddens, and G.D. Vance, the Vice President of US. So what I concerned at this issue is how the social structure changed with what we deal with the climate change issue. So okay, how can this move on? Yeah.
This is.
Yeah. Yeah. Okay. Yeah. Yeah. Firstly, as a sociologist, to deal with this topic, we should complex the triple crisis of, that is, why climate change, social justice, and biodiversity matters. It's the triple crisis. So how to deal with this question, define how we do to deal with the social practice. firstly, it was, okay. Yeah, okay. Okay. Yeah, okay. So the answer is the top level design by Chinese government. We have the firstly new philosophy. That is, green mountains. Green mountains are good mountains integrated into the casual evaluation. In Chinese, we call this theory with the two mountains. It is totally changed the philosophy of what is development. Development is not only the economic growth. The second is the government designs the 1+N policy cluster, a coordinated policy framework for carbon peaking and neutralization. And the third is the legal shift from controlling energy volume to controlling carbon emission. So all this change was designed on the political and institutional created by the government. So the rest thing is we can see the translate of the practice of the translated framework in the concrete practice. The firstly is the policies in action. We start from two aspects, from the carbon governance and the energy evaluation and the technical breaking through. The firstly, you see, the Chinese government, we have the annual report on Chinese policy and action for addressing climate change in publishing every year. To publish, keep policies transparent and adjustable. Secondly, that is, we found that only the technology innovation is the engine of the just transaction. That is from the theory to the practice. That is two things need to be excited of the innovation. That is the firstly of the ultra high voltage grid, transmitting renewable power across to the nation. The secondly, we can see the picture that is very proud of the Chinese factory, that is the battery storage. We have a large-scale application of the new energy storage. So now, from the innovation of the energy, we can see China now is a contributor rather than merely a consumer of the global public goods, just because of the technology and innovation. So let's come to the second question. That is, what is the social justice dimension? Yes, because you know, China is a very huge rural country. We have 14 billion people now. At least about 50% people are living in the rural area. So it's a big problem to deal with the clean heating for the rural environmental equality. So I can give some cases. That is the project replacing the coal stove in 3.5 million. Northern rural homes demonstrate that the vulnerable groups are the starting point, not just a suffering point. That it's only happened in the north part of the China because China is so big. At the south part of the China, the rural people doesn't have such problems. So the vulnerable groups are not afterthought. They are the starting point of the project design, along with the human rights approach emerging in the climate litigation. So the second aspect of the justice dimension is the green skills training and the just transition safeguards. So here we can see this also Chinese practice. We start from three aspects. The mainly driven is the carbon market transition. We allow the transition period for high-emitting industries to avoid employment shocks. I can give you an example. That is, this carbon market allows transparency period for the steel and cement plants, the traditional industry plants. So many works lose their jobs, but the remaining program that moved 200,000 workers from the coal to solar panel factory in Shanxi province. Just a case from this province. That this is a replicable template that can, for other developing countries, can adapt this model to avoid social shock. So, comes to the last topic, that's the biodiversity and the local livelihood. And it also was driven by the institutional design through the national park and the community co-managed system. Till now, yes, just within these 2 years, that China has rezoned 23% of our territory and the protected area system. I'll give you an example. That's the Panda National Park. It's a very famous panda in the world, and we have limited an area as a national park. And in this area, the logging are banned. And coupled with the eco-tourism, it's very fashion in China. And the local people joined in these jobs. And the carbon sink payment for the local villagers. And another case of the biodiversity is from another province of Gansu province. It's from the Qilian mountain. So in this mountain, it's in the core of the west and north of China. And we reenacted the free treatment of snow leopard habitats and restoring natural migration patterns. So what happened after we have restored the environmental, that is the local villagers, now they can they can sell their certified organic beef at their house and with a local economic brand. So at last, China has do a very unique role in this climate change, because it's totally driven by the political level, a top-down design, and comes to the developing countries. So Chinese experience to the global governance can be adapted by the South and all these developing countries. It's a way demonstrating that we have shared but different responsibilities can be operated without imposing green conditions that amount to trade barriers. So all we talk about so much, that is towards a community to life for men and nature. So this picture maybe is not familiar to foreign people. It's equal to the panda in China. It's very unique monkey with gold hair monkey in China. So let's back to the concrete Chinese narrative policy innovation that we can see with the conference of 2024 to 2025 legal movement as an opportunity to embed this the Chinese practice into the international soft law instrument. So at the end, so I invite all the fellow scholars and the institute to cooperate for the comparative research and to incorporate in the ecological civilization matrix into the future climate and biodiversity something. So here comes the end. Thank you all.
Thank you very much. Not being an expert of sociology, what I got from your presentation, very interesting presentation, is that, let's say, there is an ongoing process of various ongoing processes of adaptation. Indeed, let's say, countries, populations, governments, local authorities are going towards adaptation. Maybe it's a realistic conclusion that climate change cannot be eliminated as such as a problem, so it's necessary to try to get to put in place measures of adaptations, and it seems to me that the Chinese government is also following this way in order to reduce in a certain way the damages. Usually we think about adaptation concerning wildlife, natural life, trees, plants, but also human beings, and our lifestyle need to adapt to this new situation. And then we have our last speaker, which will open another field of reflection, which is the cultural perspectives on biodiversity in the ocean governance. And we know very well that not only indigenous people, but also any individuals is facing cultural challenges because of climate change, and also with respect to part of the problem, which is the oceans. And who could be the best person to speak about that cultural issue than a professor coming from Ecuador, since Ecuador is a country very advanced in recognizing, protecting cultural issues of the populations living in Ecuador. Professor Danilo Garcia, our next speaker, is Professor of International Law in the Central University of Ecuador. Please, you have the floor.
Buongiorno a tutti. Io decidere due cose. Primo, mio cuore sente importantissimo agradecer in italiano. Grazie mille al Consiglio Nazionale delle Ricerche e grazie mille all'Istituto di Studi Giuridici Internazionali e grazie mille Gemma Andrione, professora Andrione, grazie mille per l'invitazione. E secondo, my dissertation I will continue in English because my Italian is not so good. So I would like to start to say that is very, very important. It's an honor to speak in this to share this conversation with the personalities as you, for to speak about cultural perspective in ocean governance. I will invite you all to travel imaginary, to travel to different cultures around the world. The accelerating degradation of marine ecosystem call for a profound rethink of the legal and ethical foundations of ocean governance. Since the beginning of the time, since the beginning of the human life, the rapport between the human and the marine ecosystem that was very strong. In the Greek culture, the rapport between the human with the marine resources, that was about God, Zeus, that was about the spiritually rapport. For the different cultures in different time, and now for the indigenous people or for the different cultures as Inuit people or in Africa or in Asia or Latin America indigenous populations, our rapport with the maritime resources is one point of life. Actually, the rapport is about the religious also. When we remember in the Catholic religion, when Jesus multiplied the fish for to share with his group, that was not only one thing of ruler or the legal or juridical issues. That was one thing about the survive. In this time, we have the same issues, the same challenges to protect, to conserve, to protect the maritime resources for our life. That is important in this report. Why? Because all the states, all the people around the world, we start with different agreements, we make the different agreements, we discuss in different scenarios, in different countries, in the universities, in the political government, and we made the declaration as our ocean, our future, 2025 agreement of United Nations. But I want to explore how cultural diversity and indigenous cosmovision or world views can contribute to a more inclusive, equitable, and ecologically ground governance of the oceans. Central to this discussion of this analysis, I will show you how Ecuador constitutions of 2008 made the nature as a subject of law, a subject of rights. And now the different countries, actually the European Union, discuss how important could be take this point of view. But in the same country that in 2008 we discuss and we make that in our constitution, now it's discussed to change this constitution. And that is very, very interesting and bad in the same time. This weekend, this Sunday, we will, the Ecuadorian people, we will vote for to change or not the constitution. That is the very incredible, step, because around the world we speak that the ruler is very protected to the environmental resources, but now the political issues or the political challenge give us the opportunity to reload this vision. I would like also to examine how this Ecuadorian vision interact with international instruments such as the United Nations Convention. Yeah. Okay. And how ocean governance has entered a critical stage in which ecological degradation, climate change, and loss of marine diversity demand not only scientific and legal response, but also ethical and cultural transformation. As underscored by the United Nations Declaration, Our Ocean, Our Future, there is growing consensus that sustainable ocean governance, thank you. The ocean is not only the physical space governed by law, but also a living reclaim and meaning, identity, and heritage for the different cultures. I want to explore how cultural diversity and recognizing of the rights of nature, particularity as expressed in our constitution, how to contribute to incorporate these traditional knowledge to the different roles of law. Contemporary ocean governance is undergoing a paradigm shift, while traditional legal instruments such as UNCLOS remains foundational. There are increasing complement by ethical and cultural frameworks. When we speak about cultural perspective and ocean governance, we need to understand how global ocean crisis is dangerous to survive the human. Degradation, overexploitation, pollution, climate change is several examples. But also, we need to understand how in different traditional knowledge this kind of relation with between humans and law is important. For the Polynesian population, the conception of the ocean is intrinsic, is part of its life, like a Moana vision emphasize a kinship with connectivity, the connection between human and natural resources, especially with ocean, is part of her culture, their culture. Similarly, for the Inuit people in the Arctic, the rapport with the Arctic is part of its life. The traditional knowledge that was incorporated in several instruments like a Universal Declaration on Human Rights for the Indigenous People from 2007, Articles 25 and 32. They express their right to be part of their discussion, to be part of their governance, to be part of that participation. The several other instruments, the juridical agreements here in European Union permit not only to have the good information, but to prepare the good participation and to have the opportunity to go to the explain the climate justice. These 3 steps that very important to express the traditional ecological knowledge, the famous TIC. About culture as a pillar of marine sustainability, we can say, for example, in Ecuador, we have the Galapagos Island. The Galapagos Island in Ecuador is one of the more important examples that how the local fishers implement the knowledge of seasonal migration and bringing the different zones to catch the different crabs on to fish the different seasonal fish. A similar approach are found in Pacific and Caribbean nations where communities based marine areas. What about marine areas? The MPAs, the Marine Protected Areas, is one of the more important tools to protect that part of the oceans, not only in space, in juridical zones, but beyond of juridical zones. Now we have the BBNG agreement, but the discussion about that incorporate the local knowledge, and the problem is that in the practice is not to take in the real part. They only discuss about the different typical indigenous knowledge or the different cultural approach, but how we can to implement that approach in the real governance. That is the real problem. That is the real challenge for the juridical agreement, because only to have in the agreement, I'm lawyer, but I need to say that the different agreement, juridical agreement, sometimes is only ruler right, but no, there is not implemented in the local context. And now how important is to make in the inverse, to make in the other side, not to make the rural agreement treaties and is to try to implement it in the different cities or local activities. But now the more important is to make the incitation from the local to the universal, to the local practices, with the local practices, to the universal agreement. The indigenous worldwide see the ocean as a living being. The traditional system shows the world how this knowledge that was important to have an approach for the conservation, and the technical and the scientific issues permits to confirm this knowledge. The cultural diversity, exchange social legitimacy, and long-term compliance of marine policy. How traditional knowledge and maritime biodiversity tech permit the effectivity of conservation, the effectivity of law also is not thing, but not opposite. The knowledge accumulated over a generation on spaces covering an ecological realms. We have 2 examples. The first one that I talked about about Galapagos fishers, but other the Caribbean and Pacific community. based marine management systems. All about that, we incorporate in several treaties, international treaties, but the implementation is the challenge, how important the local communities to the marine governance. I spoke about the different rules of law as in Ecuador since 2008, but also the second country in South America is Bolivia. Bolivia also changed its constitution to make the indigenous worldwide and to express this possibility, or not express, to remark this possibility to declare the nature as a subject of law, as a subject of rights. Our constitution has specifically the articles 71, 2, 3, and 4, inspired by one cosmovision as the good life, summa causa, the buen vivir, the good life in harmony with environment, and introduce the new biocentric approach, and the lesser part, the anthropocentric approach. The anthropocentric approach, that was one of the more common point of view when we need to remark the rules of law. But that was recognized not only for our constitution, but also for different courts with consultative opinion. Yesterday, we're hearing about the opinion of Inter-American Court of Human Rights, that its opinion 32 remarks the importance to guarantee the participation of indigenous people, the participation of all of us, not only the cultural groups, not only the formal groups, but the everyone. And that was recognized also for different tribunals like ITLOS, like International Court of Justice. And that opened the door to the new ethical horizon for ocean law. The new ethical horizon where we can to guarantee the rights of natural entities recognizing globally. That maybe sounds as EP issues, as EP point of view, but no, now it's one of the more practical issues that we need to incorporate indigenous principles like responsibility or co-responsibility or liability and co-liability that is discussed since several time ago. The governance transformation is to change the control to care, extraction to coexistence, and instrumentalism to respect of living beings. However, we need to incorporate all the cultural plurality for sustainable ocean governance, because we are concerned all, and we incorporate only in the text, but we don't incorporate in the practice on how to the government could be guaranteed its participation, its real participation. But the more and more we make it, but now as obligation, we need to confirm this part of traditional issues. For to conclude, I would like to say to you that all of us in one moment, we needed to hear to each other, or we need to express our sentiment, our feelings, our lives, our cry. The planet cries and we need to hear it. Our relationship with the natural resources is not only about the conservation, it's about our survival. Thank you very much.
Thank you very much, Professor Garcia. I remember, anything confidential, of course, I remember that the first day of the hearings before the tribunal, the causes, the representatives of causes opened the hearings with their arguments, and the first speaker was a lady from a small island state in the Pacific Ocean, who was dressed in the typical way with some flowers from that island, and she spoke about the Mother Ocean, and she explained us the particular link between their story, their cultural heritage, and Mother Ocean. So hearing you, I thought about this lady, and I must tell you that being a positivist European woman, I'm always a little bit in trouble in understanding and not accepting, because it's not a problem of acceptance, but in understanding and how can I say, fine-tuning with different approaches. But I think I admire a lot the Latin American approach, which is able to leave this European and Western pragmatism and try to find out in cultural heritage from indigenous people a new legal dimension, which is this dimension of the nature as a subject, and which is very in line with the Latin American approach to life in every field. So thank you, because I think we have concluded this panel with something different from what we are used to hear. So I think now we have a Q&A session. I speak under the control of Gemma, who is our cheerleader in that. And so I come back to the seats, and I don't know if there is any question. Question from the public? There is someone, which this someone is Professor Gauthier, please.
Just a question. It's not a legal one. It's more to Professor Nesi. On the baseline, I share to a certain extent your optimism, in the sense that the fact that baselines would not change may be good for some more vulnerable states. But is it not also the fact that from among the 193 member states of the UN, there are more or less 140 coastal states, and therefore everybody among those states is interested in keeping the maritime territory. Dus it's a générosité bien comprise commence par soi-même. I mean, it's perhaps also self-interest. Just to hear you about that, or for our colleague from Ecuador, Perhaps just a question on the legal status when nature is recognized or part of nature. What is the concrete implementation in the legal system? I mean, who is the protector or who could act for nature? Is there a specific institution there? That would be interesting to hear you about that. Thank you.
Thank you very much. And I think that yours is an assessment rather than a question, and I completely agree. However, I think that it is also important to, as regards to the awareness of the 193 member states regarding sea level rise, it is important to recall that at the very beginning of the negotiations, at the very beginning, I would say, of the activity of the International Law Commission on the topic, not all states who now, with the final report, shown a general agreement on the result of the work of the International Law Commissions were on board, so to say. So there were, I remember, even before I went to the ILC, I remember that I read that some states were very skeptical with regard to the activity of the International Law Commission on sea level rise. Some of them were landlocked, I must say, but I think that even they now understood how important it was to put this topic on the agenda of the ILC and the importance of the results that have been achieved so far. Of course, we are surely much more in the field of progressive development rather than codification, but as I said in my presentation, the awareness of the importance of the issue, and also the fact that thanks to the work of the International Law Commission, there is a common understanding of some of the main issues at stake. In my humble opinion, is a great merit of the work of the Commission as such. So you are right that by saying that it would have been difficult. You know, it's like saying that we have to fight mafia. Everybody knows, but how to do it, and what are the main topic to be addressed when you want to deal with a certain issue is also quite important, especially in a moment like this one of crisis, of attack to multilateralism. So I think that in this regard, frankly speaking, I'm very proud that I participated in the work of the Commission also in this phase. Thank you.
Other questions? Professor Scovazzi? Maybe. Oops. Okay.
I'm so sorry, but only for to answer. About Ecuador, is the environmental topic is transversal, and it's not only in the agreement, in the constitution, in the law, but also in the institutions and transversally in all of issues in the government and the public participation. For example, we have the environmental ministry, but we have also in the juridical part one prosecutor only for the issues about the nature. We have inside the police, we have a united one group, a specialty for the environmental issues. We have also the different participation and arenas for discussion with the indigenous people only, but with the indigenous people and the the Ecuadorians in general, and we have also a big part of Bomba. So relativity, the big part of our governmental money to the financial this discussion, this part, the participation of indigenous people, the participation of all of the Ecuadorian people about this kind of topics, and the collaboration between the local governments and the national governments with this kind of topics. So actually the environmental issues is one of the more transversal subject in our normal life or institutional life in that. How to make that? We made about the in the positivism rulers, we make it, we include in the rule of law, but we exert, we making plus, with making all this part in the different kind of topics, science, education, formal education, and the indigenous education. We have the two parts. Actually, in our criminal code, we have also the jurisdictional formal authority for the indigenous only. And that is very interesting, but that is another kind of problem in how we make inside our country two formal justice administration. The normal justice administration, but for the several kinds of problems, for the indigenous only, the indigenous people have the authority to have and to decide that problem. That is very anthropologically way. That was very hard to include that in 1998, but now is our common right. In our right, we have the formal law and the indigenous law also, but the environmental issues is transversal for all. That's right.
Thank you. Sorry, I forgot. Professor Scovazzi, I think. Please.
Thank you. My two questions are addressed to the same speakers, and for Professor Nesi, the International Law Commission has clarified the question which was not addressed in the ITLOS and has concluded for the stability of baselines. Do we need, I wouldn't say an amendment, but an implementing agreement in addition to the ITLOS to clarify this point? And for Professor Garcia, the cosmovision of indigenous peoples is a cultural factor that needs to be protected. It is not only a land vision, a link with the land of indigenous population, but it is also a sea vision, a link with the sea of some indigenous population. Could it go as far as to prevent deep sea mining activities? That's my question.
Thank you. So, Professor Nesi first, and then
Okay. Thank you very much. UNCLOS, as we all know, has been a lengthy negotiation. Has been the result of a lengthy negotiations, and I would say that in 1982, more than 40 years ago, a certain equilibrium was found within the negotiations, and the byproduct, frankly speaking, is something really important for the international community as such. Professor Scovazzi asked me whether, in order to take into account something that was not thought about at that time, would be wise to amend the convention on the law of the sea, or to do something separately. I would say that, going back to our considerations on today's cataclysmic moment in international relations, I would say that maybe it's wise to sit and wait, because my fear in this moment, in a moment in which one of the most important political personality of the world speaks about IMO on Twitter, on X, how do they call it, as it was recalled by Lorenzo. Maybe it is, and not forgetting that, for instance, the United States are not parties to UNCLOS. I would say that we should try to do all the efforts to keep what is there. Even the United States, at least in the previous administration, decide that stability of boundaries is something that must be preserved. So at the moment we take for the official position of the United States, the one that was made, if I'm not mistaken, in 2023, and I will stop there, because my fear is that if we open negotiations on any type, of course we can use particular negotiation technique in order to preserve the acquis and not to touch it, but reforming certain aspects of the convention. But I am afraid that the famous equilibrium I was referring to at the beginning could be jeopardized by any even little modification of international conventions. So my opinion, maybe I'm too cautious, but I think that this is also the feeling of many of the members of the International Commission. The best thing to do is to wait and to consolidate certain aspects, also on the stability of boundaries and continuity, etc. And when time will be ripe or better, maybe we can start thinking about the follow-up. But for the moment, I am very, very cautious, and I would suggest to be cautious.
Thank you, Professor Garcia.
Thank you very much. Thank you for the question. It's very, very interesting how to make all the discussion in one question. Thank you for that. Actually, when we speak about the traditional ecological knowledge, we need to think about not only the indigenous people knowledge or indigenous people traditional knowledge. We need to think about the rapport between humans and nature. And its report, the indigenous people report, the indigenous people cosmovision, they explains how we can make a solid report, a solid coexistence. And since that point of view, we can express not only with the biodiversity of the land or trees or forest, but for everything of Gaia, Gaia as the Mother Earth. Now, about only the sea and the marine resources. One big example in Ecuador is how the local fishers implemented their knowledge, for example, for the migration seasons or for several species, how to catch different species in different time, and how to repopulate, how to make the new tools for conservate one space, for example. And that is, from my point of view, that is one big step to the first implementation, the marine protected areas. The Galapagos Island was one of the first, not the first marine protected areas in the world, in our conception. But that was one tool inspired by traditional ecological knowledge, and also that improved not only for the conservation programs, but also for to make the balance ecological protection with community livelihoods or similar approach in different zones. So for the question, yes, I think could be good to implement to conservation for marine resources, for habitat, for fauna and flora part of biodiversity, but for sure, for to continue this report, human nature. Thank you.
Thank you.
I just have one question. Sorry. For Jing Luo and Lorenzo Schiano di Pepe, just to also conclude the traditional knowledge issue, because I'm wondering if in China, for example, there is this idea of complementing science with traditional knowledge, even detached, disconnected from the indigenous people rights. I mean, so the idea of having traditional knowledge of rural people, you made reference to, so something that is not science, that is considered in your policies or regulations. And the question for Lorenzo, if traditional knowledge has had a role in IMO discussion, because I really don't know, actually. I didn't say. So.
Thank you, Gemma. Please.
Oh, okay. Thank you. Very good questions. And this is maybe the biggest misunderstanding to China. That is, as a long history, a huge country. So how we deal with the traditional wisdom, the local wisdom, to deal with the new problems, such like the climate change. So it's a long way to go. That we have a history of more than 1,000 years, and we have so many traditional wisdom and local wisdom. But all these wisdoms are deal with the surviving. That is nearly 20 years before, for the local rural villages for the China, it's about 10 billion people. Okay, struggle. So they just struggle for surviving, to get rid of hungry. So such as the topics in Europe, that is environmental protection or something that is not in the traditional knowledge system. So that is why when we face this new topic of climate change, so it's a so strange combination for China because firstly, we must limit our consumption. Secondly, we are a huge developing country, so we must deal with, basically for the rural areas, deal with the adaptation of the climate change. For these two kind of things combined together for common China, so that is why this is also we Chinese scholars point out that the history, the traditional and the local knowledge does not work. So that is, so we have passed away in the last 20 years. That is, it's designed of the top-down design, institutional design to face these problems. But I believe in the future, when we go on this way of how to deal with the climate change, because it's totally new for Chinese people. So the local wisdom and the traditional knowledges may work in the future. Thank you.
Thank you. Lorenzo?
Thank you for your, Gemma, for your interesting question. Not to my knowledge, and I would say quite the opposite, but if you allow me to say so, in a positive way, and I will try to explain myself. The IMO stays at the other end of the spectrum. So we know that international law, and in particular international environmental law, has a strong debt towards the hard sciences. So scientific developments and technical developments. So what is of interest for the IMO, I would say, is the, let's say, most up-to-date scientific discovery, most up-to-date scientific development, because it is on the basis of new scientific knowledge and of new techniques that certain environmental objectives can be incorporated into the industry, and these can be incorporated in the industries, and certain environmental objectives pursued. So these two elements, together with the economy, are the main driving factors of IMO regulations. Of course, we are talking about a business which must be profitable, and regulation cannot go as far as rendering it unprofitable, because when the technical changes to fleets and procedural obligations are no longer bearable by the private actors, then we have a problem. Of course, private actors and the maritime economies, such as the large flag states, play a role, and they try to put forward their arguments. It's the work of institutions such as IMO and their staff to try to find the mediation which is acceptable for everybody.
Thank you. Yes, certainly.
Thank you very much. It's not a question, but I would like to refer here to an example. On a Greek island, Amorgos, local fishers have decided to abstain voluntarily for fishing at several periods of the year, because, of course, they have found that there was a deplenishing of the fish stocks. And then they took this decision with the local authorities of the island they did a program which is called Amorgorama, and they went to the central state and asked for the law enforcement police and the sea police to help them to supervise this around the island. And this was a decision from the local people, having the knowledge of which species should be protected. This was from the local to the central authorities. The Prime Minister was there. They declared, of course, the beginning of this plan. And the central authorities took the responsibility to supervise this zone. Thank you. It was just a good example, maybe.
Yes, really good. Yes, really. It indicates very well the approach should be taken. Any other questions? Okay, so I think that now is time for a break, for the lunch that Gemma will have organized in a perfect way with abundance as usual. So enjoy the break, and we will see back at 2:30. 2:30. 2:30. 2:15, a mediation within IMO. 2:15.